Okay. Let's go on the record on cause number DC 2114491 Shift Key LLC versus the Riverview Nursing Facility. Council, make your appearances.
This is Logan Adcock and co-counsel Jay Evans for the plaintiff.
I can't see who's speaking. Who is that?
Logan Adcock at the podium, sorry.
Okay, because it says Dallas North 42.
Judge, we just moved into a new space. This is actually the first time we're using this Zoom room, we call it. And so I apologize if there are any technical issues. I could try to, I don't know how
Okay.
to.
Don't worry about it. I just want to make sure I'm the right person.
Can you spell his name for me though, please?
Logan Adcock.
Okay, and who's here for the other side?
Good morning, Your Honor. This is Carl Schurz and Jessica Rolls on behalf of the defendants Riverview and Dutchtown.
All right, you may proceed.
Thank you. As a, I guess, preliminary matter, Judge, we had, Mr. Schurz and I spoke about the trial setting and spoke separately with your coordinator or the clerk, I can't remember exactly who, about possibly moving this trial setting to a special setting. I don't know if we want to take that up now or after the motion to exclude, but we were asked to amend the notice of hearing to note that you would take that up today.
That's fine.
You want me to go ahead with that then?
Whichever, you want
Okay.
to do first is fine with me.
I don't know if Mr. Schurz has a preference either.
Logan, I think we should go ahead and address the special setting first.
Okay. It's pretty simple. There are just a few issues, Your Honor. I think we both have some scheduling considerations on both sides. I don't know if you saw last week, we had filed a motion for summary judgment. There was some confusion with the scheduling order. I think a couple of dates got flipped around there with the deadline to file a dispositive motion and the deadline to hear a dispositive motion. So we filed that motion on the date listed in the scheduling order. That was the 12th, which put us exactly 21 days before trial. The court informed us that the court cannot take up dispositive motions on the day of trial. And so one reason we would like to bump this a little bit if possible is so that we could go ahead and have that heard. I think a second issue, which is maybe more productive or hopefully will be, we received last week, when I say we, the plaintiffs received some information from the defendants related to some settlement discussions that we had at our mediation. And in furtherance of those discussions, we're hoping that will be productive. We're certainly going to continue talking about it, but it's certainly information that the plaintiff is very interested in that may help get this settled. We just got it on, I believe, last Thursday or Friday. So we just haven't had an opportunity to confer on that and really dig into it. Obviously, if that's productive, we won't need a trial setting at all.
So none of that is really relevant to a special setting, though.
Well, Your Honor, if I can add to that as well, and Logan, if that's all right with you.
Of course.
We are also having some logistical issues on the part of the defendants. They're two small nursing homes in Missouri. So they have limited resources and limited staff. So it'll help with their travel and working out staff to have a special setting. And currently they're dealing with this latest iteration of COVID at the nursing homes. So it's impacted them, and that their staffing is really lean. So it's affecting their staffing. And so for our witnesses to have to come down in the middle of that, it's going to be very, very difficult for them. And the other item that we've just learned is one of my main witnesses, a family member has now gone into the hospital. And so she's got to deal with that family issue in addition to trying to manage this COVID iterations that's going on. So moving this trial setting and then a special setting would be very, very helpful to the defendants right now.
Okay, that's a little, I mean, it's a better argument for the special setting. But you said there's a chance this may settle, is that, that's what the plaintiffs, I guess the plaintiff's attorney said?
Well, that's the goal. If we can get there, it's going to depend on how my client views the additional information that was provided. I don't want to go into the specifics of our settlement discussions, but it is information that
Have y'all been to mediation?
we have, and these documents that we received were discussed at the mediation. I think the defendants were just working to obtain and provide this.
Okay. Because just so you know, from the court standpoint, we only have a limited number of special settings, right? We have every week for the next, I don't know, 8 months or so, we have on average 15 to 20 cases set every week, just about. Some less, some more, but and so if we specially set a case, we stop setting cases that week, which makes, it potentially takes us out of a week of trial docket, which is very difficult right now. So I understand why the defendant needs a special setting. I'm concerned about giving one while there's the possibility of settlement. What needs to happen for your clients to make that type of decision, I guess?
I probably need, we probably need a week or two to just get everyone together. I'd like the clients need to look at it, and then Mr. Schurz and I obviously would need to discuss it further.
But didn't you say that you had these documents at mediation?
No, they were discussed, and we had requested them, or the defendants offered to provide some additional documents that may assist with that consideration.
Okay. Why don't you do this? Why don't we reset we'll put the request for a special setting on the docket for next Monday. You have a trial setting on October 3rd, so that you guys can talk through the settlement discussions. If you're going to settle, let's settle it. I don't want to have to waste a trial setting, a special setting on this. And then we'll just kind of figure out if we need to reset this. I don't want to reset this. I mean, the two reasons we gave, which is you might settle it and you want to follow summary judgment, absolutely do not help me. So maybe it's a reason for a continuance, but it's definitely not a reason for a special setting. Do you know, defense counsel, are your clients available on October 3rd? Do we want to just make that a special setting?
They are not, Your Honor.
They're not available on sorry, did I say October 3rd?
Yes, Your Honor. Because of this COVID outbreak and with the health situation with the relative that's in the hospital, they don't know, how, if that's going to deteriorate or not.
Okay. Yeah, you guys talk through these settlement discussions. We'll reset this request to next Monday at 10. Rhonda, reset the special setting. Put it as a status conference on the special setting for next Monday at 10. See if we can't settle the case, and then we'll try to decide if I'm going to reset the case or not. All right, let's do the motion to exclude.
Thank you, Your Honor. Quick background on the case. This is it's not a complex case.
I've read everything on
Okay,
this, so
great.
you don't need to go through
Perfect.
the background. So the issue I have is my read of the experts, they seem to be qualified to testify about this particular topic, which is, I guess, the reasonableness of these medical bills. What do you feel is missing out of their background that would prevent them from testifying about that?
Well, respectfully, that's not the issue. That the two experts, Ms. Thorson and Ms. Jones, were designated to testify. And if I can just quote briefly from the designation, the issue is whether, with respect to their defenses and counterclaims, whether our client Shift Key billed the defendants for nursing shifts that were not actually worked or that were not properly approved. So this isn't a medical bill question. It's a contract performance question.
Okay, I don't know that I just necessarily totally agree with you on that, but okay.
Well, if I can read what their designation states about both the subject matter of these experts' testimony and also the general substance. The supplemental expert designation is where these two experts were first introduced. And the language for both the general substance and the subject matter is identical in that designation. And it states, and if I'll read it for the record, it's very short. Plaintiff, Shift Key, is demanding payment for shifts that were not worked, that were not approved, and for shifts that were fraudulently validated by an unauthorized individual or individuals, among other things. Shift Key is demanding payment for shifts that are inaccurate. Further, plaintiff, Shift Key, provided the nursing homes with independent contractors who, on at least one occasion, engaged in criminal activity. That's the substance and the summary of those experts' opinions. It has nothing to do with medical bills. It's whether timesheets and shifts were properly approved under the two relevant agreements at issue in this case. And in fact, the response that the defendants filed Friday evening, it actually references those specific contractual provisions related to approval of timesheets. So the argument really is twofold. Number one, Your Honor, we ask that you would exclude.
Oh, is that papers that I showed
I think somebody else is talking on the Zoom.
I showed Katie the ones that the link.
Should I just continue on?
Yeah, go ahead.
Thank you. So the argument is twofold. Number one, we're asking the court to strike the opinions because they're not helpful to the jury on these issues. And number two, because they're not reliable. And I'll address the first issue here. The opinions are not helpful to the jury. There's a lot of case law, and the Texas Supreme Court has told us that expert testimony is not helpful to the jury and should be excluded if it involves matters within the average juror's common knowledge. Your Honor, I think that's what we have here. The jury doesn't need expert assistance to understand the evidence or determine the fact issues that are listed in the defendant's expert designations. The question presented by those designations is whether Shift Key charged them for shifts that were not worked or that were not properly approved under the agreements. But the two agreements at issue, they set forth the parties' obligations. They control the process of approval and disputing those shifts, whether that was done properly or not. The average juror can easily consider the testimony that they're going to hear from the lay witnesses and the documents that they're going to see and the communications. They can easily consider that to determine whether the timesheets were properly authorized. Now, these witnesses, it's not really a question of qualification necessarily. I understand they both have significant experience in accounting or the assisted living industry generally, but that's not going to help the jury determine the specific issues here, which is whether the timesheets were properly approved. The attempt here is to dress these lay witnesses up, put them under the cloak of expertise so that the jury, when they hear, well, this is an expert and I'm telling you that the timesheets were not properly approved, that's going to add weight to their lay testimony. It's going to add authority that otherwise the jury wouldn't necessarily give those experts. And the jury is more likely to defer to what those witnesses say because they're called experts. Now, additionally, there is one minor qualification issue, and that is not in the expert designation, so we wouldn't ask the court to consider this anyway, but it was raised in the defendant's response to the motion. And that is, really a contract interpretation issue. Were the timesheets properly approved? again, that is something that's set forth and addressed in the contracts. In fact, it's quoted in the defendant's response, those contractual provisions. Whether that's a contract interpretation issue, it absolutely would invade the province of the court to allow a witness, expert or otherwise, to try to interpret a contract. The Coker v. Coker case, it's a Texas Supreme Court case that we cited in our motion, is pretty clear on that point. That contract ambiguity is an issue for the court to decide. It's not a fact issue. And to the extent that they're saying or attempting to argue now that the contracts are ambiguous or that the approval process is ambiguous, that is not something that an expert of any qualification is permitted under Texas law to testify about. And then, Your Honor, even if you decide that these witnesses' testimony would somehow be helpful to the jury in determining these issues, the opinions as stated in the designations are not reliable. And these are non-retained experts, so we don't have reports. All we have is a designation to tell us the substance of these experts' opinions and how they arrived at those opinions. The defendant's response that was filed on Friday sort of cherry-picked some language from various cases, the Texas Supreme Court case, Gamble v. Jack Williams, and then a Dallas Court of Appeals case called Beamer's Private Club v. Jackson. And they cite those cases to support their argument that this is not scientific data. This doesn't require some sort of special qualification or education for an expert to testify about certain issues. And these cases say, you know what, in some cases, a witness's experience alone can be sufficient to qualify them as an expert. We agree with that. I think both of these cases are instructive, but for different reasons. Judge, in Gamble, while the Supreme Court said that yes, experience alone could qualify a witness as an expert, they also say that all expert testimony should be shown to be reliable before it is admitted. And to be certain that an expert qualified by experience is offering reliable opinions, the courts ask whether there is too great an analytical gap between the expert's data and the opinions the expert proffers. And then, Judge, I know you're well aware of this, but just for the record, an analytical gap exists if an expert fails to demonstrate how her observations support her conclusions. And then in the Dallas Court of Appeals case, they cite Beamer's. We see how the Dallas court applies that rule to a motion to exclude and to consider whether there's an analytical gap. In that case, it was obvious to the appellate court there was no analytical gap because the expert listed a laundry list of documents, photographs, videos, affidavits, deposition transcripts, legal requirements that the expert considered to make the ultimate determination in his opinion. Now, compare that to this case. The conclusion in this case is that Shift Key's demanding payment for shifts that were not worked or that were not properly approved. So even if the court determines that the jury needs expert assistance on the issue, the opinion, it still has to be reliable, and they're not.
All right, I've seen this response.
Yes, Your Honor. So the defendants contend that the underlying contracts that plaintiff is suing on required the plaintiffs to get the defendant's approval and that they would not bill us without that approval. So that's what is at issue, and that is what is being contested. But we've also pled ambiguity. And so at the very least, in the alternative, to the extent the court disagrees with our construction, it's ambiguous, and it will be for the province, for the jury to assist the court with.
Why do we need these folks to be experts as opposed to just witnesses?
Right. Well, Your Honor, they are to a large extent fact witnesses, but also given their experience in the nursing home industry, both in administration and also in the accounting procedures, that also goes into their expert knowledge and experience. So these witnesses will talk factually about the fact that there was an approval, how much was at stake, the impact it had. But then also, Your Honor, they're going to assist the jury because they could talk about the nursing home field, the industry, what was going on, what are the particular circumstances with nursing homes, in particular with these defendants, but then also depending on what the testimony is with plaintiff, what happens generally. They will also talk about, this happened from August 20 to 21 about COVID, how that impacted the nursing homes, how that impacted the industry. So all of this background are of the nature that will assist the jury. That's something the jury needs to understand. It's something that's going to be relevant. It's something that's going to be helpful to the jury. And it's the type of information that's relevant and admissible. And if there is a finding with the jury instructions that there's an ambiguity, then there may be interpretation or there may need to be testimony about the industry and how that impacts the ambiguity. And this is the type of testimony where you have fact witnesses, but also have this type of expertise in an industry that is relevant and kind of crosses over fact testimony and expert testimony. As the Texas Supreme Court said in the Reed Road case we cite to, there's often a fine line between when testimony is factual and when it becomes expert testimony. And as the Dallas Court of Appeals said in Beamers, this type of expert testimony, which is based on personal expertise, that's the type of testimony that is admissible under Rule 702. And so this is something that this testimony may depend on what the plaintiff's case in chief said. This is something that's premature to decide now, that should be decided during the trial, at the time of trial. They will have the opportunity to cross-examine these witnesses. And the plaintiff took the deposition of Ms. Thorson. So not only did they have the expert report and the supplemental expert report, but they took her deposition too. So it is premature.
You said she created an expert report?
Well, no, Your Honor. It was in our expert disclosures, and then they deposed her.
Okay, you said, I'm sorry, I was confused because I thought you said reported, so.
I may have misspoken.
All right,
Can I respond briefly?
yeah,
A few issues here. Judge, they're fighting about whether the agreements or the timesheets were properly approved using the approval process in the contract. And they're arguing it's ambiguous. The Supreme Court of Texas is clear, contract ambiguity is a question for the court. It's not a jury question. And further, we took Denise Thorson's deposition and we have her expert designation. I read you word for word what that designation states about her opinions. It has nothing to do about nursing homes in general, the state of the industry, the Missouri standard of care for billing practices. That is all absent from the expert designation. To say that I had an opportunity to take her deposition on those issues is incorrect. The first time we heard about those issues was in the defendant's response to our motion, which was filed Friday at about 5:30. Those are brand new issues well after their designation deadline, and the court should not allow them to testify about those issues, certainly, but the court shouldn't allow them to testify about any of these issues because it simply isn't helpful to the jury. They want to prop them up as an expert on these, standard, uncomplicated fact issues.
Mr.
Your Honor,
Sheriff, can one of you guys share screen the expert designation?
Carl, are you grabbing that, or I can? It doesn't matter.
Yeah, if you have that, Logan, that would be helpful. And Your Honor, the approval process is not discussed in the contract, and so that's one of the issues in terms of the testimony and whether there might be an ambiguity.
Go ahead and share screen the designation, please.
Yes, Your Honor. Are you able to see that, Your Honor?
Let me see. Yes. I mean, just the top of it.
I'm sorry. The top is. And just let me know when you'd like me to scroll.
Just go down to the where the designation occurs on the challenged experts.
Okay, here's where it starts.
Okay. Is yeah, I guess it's the subject matter we're concerned about, so okay, and go to the next one. 3.
That's identical.
It's identical, okay. Well, it looks like keep going down. Okay, so he is right. I don't know that you really provided any type of about billing standards or anything like that. It does seem like this is more of a designation of a fact witness as opposed to an expert.
Your Honor, it's where we talk about that the experts are generally familiar with the operations and familiar with the charges that plaintiff charge and do not appear to be supported by timesheets. So that's intended to cover, hey, our operations and
But that's on expert opinion, right?
well, in terms of going into the background of the operations, how they fit in with the nursing industry and things of that nature, that would
But none of that is said in the designation, right?
in that level of detail, no, but it was discussed during the deposition, I believe.
What was discussed during the deposition?
How the operations were ongoing, the impact of COVID, and I believe there was some discussion about how that fits in with the industry.
I'll be honest, I don't recall that. And the deposition was of their corporate representative on designated topics. This was not an expert deposition, and this is asking me to get inside the mind of the defendants here and consider what they might later argue so that I can address that in the deposition. That's totally unfair to my client.
Mr. Schertz, I mean, I will say that if everything you said initially about, I mean, I could see these folks being experts, experts in the industry, billing practices, all that kind of stuff, that they're familiar with billing practices in the industry, and this is how it's done, and blah blah blah. But none of that is in your designation. That's, I guess, what my problem is. And so unfortunately, I'm going to have to grant this motion to exclude these. I'm not excluding them as witnesses, just as experts in the field. I guess you're kind of past your expert designation deadline, so they're not going to be able to testify on expert matters at trial. So is there a proposed order that's been submitted?
We could submit one this afternoon or immediately after this.
Just make sure it's clear that these witnesses are not struck as witnesses, just as experts. They clearly have issues that they can testify that they have personal knowledge of.
And I believe the court.
And make sure that it says at the beginning that this was heard on September 18th, 2023, that you submit this to opposing counsel, Mr. Schertz, and let him take a look at it. Get that to me by no later than this Thursday.
Thank you.
Thank you. You guys have a great rest of your day.
You too, Your Honor. Thank you.
Our next hearing is McKinney versus Abdul Gadir. Anyone here on that case?
Yes, Your
McKinney-
Honor. Ryan Getty here representing the defendants.
All right, anyone here for the plaintiff? Who's plaintiff's counsel on this?
It's someone at Lawn Car's office, Your Honor.
Doty, D-O-T-Y is what it looks like.
Yes, Your Honor. Yes, Your Honor. I do not know them, but that's who counsel is on this case.
Is anyone else here on this case?
I don't believe so, Your Honor. We represent all three defendants.
I'm just wondering if anybody here, there's quite a few people here. I'm just wondering what they're here for. Okay. It's unusual that Lawn Car's office wouldn't show up to a hearing. Well, let's see. Who have you been working with on this case?
Your Honor, we've been working with counsel and also his paralegal, Chantal Panetta.
Why don't you give them a call and just see if they're going to sign on, if they're what's going on, because you are also asking for continuance.
Yes, Your Honor. Okay. Happy to do that.
Just and we'll go on to the next hearing real quick.
Okay, I'll do that right now, Your Honor.
All right, thank you.